Picture this. You're a partner at one of New York's most prestigious law firms. You've graduated from Harvard Law School, argued cases before federal appellate courts, and built a reputation for brilliance that's earned you millions in billings. You walk into the courthouse wearing a tailored suit that cost more than most people's monthly rent, carrying a briefcase with case files for a trial that could set legal precedent. And the security guard looks at you and says, "Defendants need to use the other entrance." This isn't a story from the 1960s. This happened last year to attorney Marcus Johnson, and it happens to black lawyers across America every single day. According to the American Bar Association's 2023 diversity report, only 5% of lawyers in the United States are black, despite black Americans representing 13% of the population. But the real story isn't just in that number. It's in why so few black people enter the legal profession and why so many who do eventually leave, exhausted by battles that have nothing to do with the law. By the end of this video, you'll understand why being a black lawyer in America means fighting two cases simultaneously. The one you're being paid to argue, and the one you never asked for about proving you belong in the room at all. Let me introduce you to attorney Jasmine Reynolds, because her journey through the legal profession captures the exhausting reality that the 5% face. Jasmine grew up in Southside Chicago, raised by a single mother who worked as a public school teacher. From elementary school, Jasmine knew she wanted to be a lawyer. She'd watched legal dramas on television and was captivated by the idea of standing in courtrooms using words and logic to protect people who needed defending. But more than that, Jasmine had experienced injustice firsthand growing up in a community over-policed and under-resourced, where she'd seen innocent people arrested, where public defenders were too overworked to mount real defenses, and where the legal system seemed designed to incarcerate rather than deliver justice. Jasmine wanted to be the kind of lawyer she'd never seen in her neighborhood, someone who looked like the people who needed defending and who actually cared about their outcomes. Jasmine was brilliant in ways that couldn't be denied. Straight A's throughout high school, debate team captain, national merit scholar. She attended Northwestern University on a full scholarship and majored in political science while minoring in African American studies, graduating summa cum laude. She scored in the 98th percentile on the LSAT and was accepted to Yale Law School, one of the most prestigious law schools in the country. Everything on paper suggested Jasmine was headed for the kind of legal career that would make her mother's sacrifices worthwhile and would position her to actually make the difference she'd always dreamed of making. But law school was where Jasmine first encountered the exhausting reality that would define her career. Being excellent wouldn't be enough, because excellence was assumed to be surprising when it came from someone who looked like her. Yale Law School has a complicated relationship with diversity. According to their own 2023 admissions data, only about 7% of their student body is black. Jasmine arrived on campus excited and nervous, ready to prove she belonged among the best legal minds in the country. What she wasn't prepared for was the constant weight of representation. The feeling that she wasn't just Jasmine Reynolds, individual student, but the black girl whose performance would be generalized to make assumptions about all black people's intellectual capabilities. In her first-year contracts class, when Jasmine gave a brilliant answer during Socratic questioning, her professor responded with surprise that was audible in his tone. "That's actually a very sophisticated analysis." The implicit message was clear. He hadn't expected sophistication from her. When white students gave good answers, they were meeting expectations. When Jasmine did, she was exceeding assumptions. The microaggressions accumulated daily. Study groups where Jasmine's suggestions were initially dismissed until a white male student would propose the exact same idea minutes later and receive credit for the insight. Professors who would consistently mispronounce her name despite correcting them multiple times, while effortlessly pronouncing complex European names. Classmates who would express surprise that Jasmine was so articulate, as if expecting her to speak in dialect or slang. Being asked by other students if she was admitted through affirmative action, with the implication that she hadn't earned her place through merit. Having white classmates assume she'd be the expert on any case involving race, as if her blackness made her responsible for educating everyone else about racial issues in addition to keeping up with her own crushing workload. According to a 2022 study published in the Harvard Law Review examining the experiences of black law students, 83% reported experiencing racial microaggressions from professors, and 77% reported them from fellow students. More troubling, 61% said these experiences negatively impacted their academic performance and mental health. Jasmine was part of those statistics. The constant code switching, moderating her speech, her appearance, her mannerisms to fit into a predominantly white space, was exhausting in ways her white classmates would never experience. She couldn't just be a law student struggling with difficult material like everyone else. She had to be a law student while also managing others' perceptions, proving her legitimacy, and carrying the psychological weight of knowing that any mistake she made would be attributed not just to her, but to her entire race. Despite these challenges, Jasmine graduated in the top 15% of her Yale Law class and secured a position as an associate at Morrison & Fletcher, a white-shoe law firm in Manhattan that represented Fortune 500 companies. She was one of only 3 black associates among the firm's 87 lawyers. Her starting salary was $190,000, life-changing money for someone from her background, and she threw herself into the work with the intensity that had gotten her this far. But the courtroom incident that opened this video happened during her second year at the firm, and it crystallized the exhausting reality that academic credentials and expensive suits couldn't fully protect her from assumptions based on her skin color. Jasmine had been assigned to a major corporate litigation case defending a pharmaceutical company against allegations of deceptive marketing practices. It was a high-stakes case with millions of dollars at issue, and Jasmine had done hundreds of hours of preparation, researching precedents, drafting motions, preparing witness examinations. She arrived at the federal courthouse for a pretrial hearing, dressed impeccably in a tailored suit, carrying her litigation bag with meticulously organized case files. The security screening area had 2 entrances, one for attorneys and court staff, one for the general public. Jasmine headed for the attorney entrance, as she'd done dozens of times before. The security guard, a white man in his 50s, physically stepped in front of her and said, "Ma'am, the public entrance is over there." Jasmine explained that she was an attorney here for a hearing. The guard looked skeptical and asked to see her bar card, something he never asked of the white attorneys passing through. When Jasmine produced her card, the guard examined it suspiciously before finally letting her through with no apology. That incident could have been a minor annoyance, the kind of thing you laugh off and forget. But it wasn't minor, and it wasn't isolated. It was part of a constant pattern where Jasmine's legitimacy was questioned, where her presence in professional spaces was treated as suspicious or unexpected, where she had to repeatedly prove she belonged in places her white colleagues entered without challenge. In courtrooms, she was regularly mistaken for a court reporter, a paralegal, or even a defendant rather than an attorney. Opposing counsel would sometimes address their arguments to Jasmine's white junior associates, assuming they were the senior attorney because they couldn't imagine the black woman was in charge. Clients would occasionally request a different attorney, preferring to work with someone who looked more experienced, code for someone white. Inside her firm, the microaggressions took different forms but were equally exhausting. Partners would compliment Jasmine on being so articulate or so well-spoken, compliments that were never given to white associates because their articulateness was assumed. During performance reviews, Jasmine received contradictory feedback. She was simultaneously too aggressive and not assertive enough, held to standards that seemed calibrated to be impossible to meet. When she spoke up in meetings, she was often interrupted or talked over in ways her white male colleagues weren't. When she stayed quiet, she was told she needed to contribute more. The impossible balance was exhausting. Be confident but not threatening. Be assertive but not aggressive. Be excellent, but not in ways that made white colleagues uncomfortable. Jasmine watched as white associates with weaker track records were promoted to senior associate, while she was told she needed more seasoning. She saw white men who'd made significant errors on cases receive mentorship and second chances, while she knew that any mistake she made would be magnified and remembered. She observed that the few other black attorneys at the firm were disproportionately assigned to pro bono cases or diversity initiatives rather than the high-profile corporate work that led to partnership, as if their value to the firm was in being visible proof of diversity rather than in their legal skills. The message was clear even when unspoken. Black attorneys were welcome in the firm to the extent that they made the firm look diverse in recruiting materials, but the path to real power and partnership was designed for others. According to the National Association for Law Placement's 2023 report on diversity in law firms, while Black lawyers make up about 5% of associates at major firms, they represent only 2% of partners. The attrition rate for Black associates is significantly higher than for white associates. They leave big law firms at much faster rates, and not primarily because they're failing, but because they're exhausted by working environments that constantly question their competence and legitimacy. By her 4th year at Morrison and Fletcher, Jasmine was one of those attrition statistics. She left the firm not because she couldn't handle the legal work. She was excellent at that. But because the constant battle to prove her worth while managing others' biases had become unsustainable. Jasmine's decision to leave big law and start her own practice specializing in civil rights and employment discrimination was both liberating and terrifying. She was giving up the prestige, the steady paycheck, and the resources of a major firm. But she was gaining something more valuable: the ability to practice law without constantly managing white fragility and proving she deserved to be in the room. Jasmine opened her solo practice in 2019, working out of a small office in Brooklyn, taking cases defending people who'd experienced discrimination in employment, housing, and interactions with law enforcement. Her clients were primarily people of color who'd been mistreated by systems and institutions with more power and resources. The work was meaningful in ways her corporate litigation never had been, but it came with its own exhausting realities. As a solo practitioner, Jasmine faced the additional burden of running a business while practicing law. She had to handle marketing, billing, client intake, and administrative work that big firms had entire departments for. She had to compete against firms with far more resources and institutional relationships with judges and opposing counsel. And she quickly discovered that practicing civil rights law, while Black, meant facing skepticism from judges who questioned her strategies, opposing counsel who tried to intimidate her, and a legal system that often seemed more interested in protecting institutions than in delivering justice to marginalized people. But despite these challenges, Jasmine was happier than she'd been at Morrison and Fletcher because she was doing work that mattered to her and wasn't spending emotional energy on proving her legitimacy to people who'd never fully accept it. Let me introduce you to another Black attorney whose story illustrates a different dimension of the exhausting reality. Attorney David Williams grew up in Atlanta, the son of 2 college professors who'd instilled in him both high expectations and awareness of the obstacles he'd face as a Black man in America. David attended Morehouse College, one of the historically Black colleges that had produced many of the civil rights movement's leaders, and then went to Howard University School of Law. Howard is the most prestigious of the historically Black law schools, and David's experience there was dramatically different from what Jasmine faced at Yale. At Howard, David was surrounded by Black excellence, Black professors, Black administrators, a predominantly Black student body. He didn't have to constantly code switch or manage white people's perceptions. He could just be a law student, struggling with difficult material alongside peers who shared his background and understood his experiences. But David's relatively sheltered experience at Howard made the transition to mainstream legal practice even more jarring. He took a position as an assistant district attorney in Atlanta, thinking prosecution would allow him to make communities safer while working within the system. What he discovered was that the criminal justice system he'd entered was fundamentally designed to incarcerate Black and brown people, and that his role as a Black prosecutor put him in the impossible position of being complicit in that incarceration. David watched as his white colleagues routinely overcharged Black defendants, opposed reasonable plea deals, and sought maximum sentences for offenses that would have been treated as minor for white defendants. He saw how the system treated drug possession as a serious crime in Black neighborhoods while treating it as a health issue in white suburbs. He observed judges who were harsher on Black defendants even when controlling for offense type and criminal history. As one of the few Black prosecutors in the office, David faced expectations from different directions that were impossible to satisfy simultaneously. Black community members viewed him with suspicion, seeing him as a traitor who joined the system that was destroying their community. White colleagues expected him to be tougher on Black defendants to prove he wasn't biased, while also expecting him to serve as the office's racial sensitivity consultant whenever questions about race came up. Defense attorneys, many of whom were also Black, would sometimes appeal to racial solidarity, asking David to go easy on their clients. The impossible position was exhausting. David felt like he was betraying his community by prosecuting them, but was constantly questioned by white colleagues about whether he could be objective. He couldn't win. David tried to navigate these impossible expectations by being thoughtful about charging decisions, declining to prosecute cases where he believed charges were excessive or racially motivated. He advocated internally for diversion programs and alternatives to incarceration for nonviolent offenses. He tried to be the prosecutor who actually served justice rather than just racking up convictions. But this approach made him unpopular with his supervisors, who evaluated prosecutors based on conviction rates rather than whether justice had actually been served. After 3 years, David left the prosecutor's office, exhausted by the moral compromises and the isolation of being caught between a community that saw him as complicit in oppression and an institution that saw him as not quite belonging. David's next position was as in-house counsel for a major Atlanta-based corporation, a role he hoped would allow him to practice law without the moral complications of criminal prosecution or the visibility of courtroom work. But corporate America presented its own exhausting realities. David was often the only black person in executive meetings, the only black attorney in his department, and was regularly expected to serve as the company's expert on anything related to race, diversity initiatives, racial sensitivity training, responding to racial controversies. His white colleagues seemed to view his blackness as his primary qualification for these assignments, as if his law degree and professional experience mattered less than his ability to help the company avoid looking racist. Meanwhile, his actual legal work, contract negotiations, regulatory compliance, intellectual property matters, was undervalued compared to his white colleagues' identical work. According to the Minority Corporate Counsel Association's 2023 survey of black corporate attorneys, 78% reported that they were frequently asked to participate in diversity initiatives on top of their regular workload, without reduction in other responsibilities or additional compensation. 64% said they were regularly called upon to provide the black perspective on company matters, as if their race made them representative of all black people. And 59% reported that they believed their career advancement was limited by being pigeonholed into diversity-related work rather than being evaluated for their core legal competencies. David experienced all of these patterns, and the exhaustion came not just from the extra work, but from the message it sent, that his primary value to the organization was his blackness, not his legal expertise. The exhaustion that Jasmine, David, and thousands of other black lawyers experience isn't just about long hours or difficult work. All lawyers face that. It's about the additional burden of constantly navigating spaces that weren't designed for you, that question your presence, and that require you to perform flawless excellence while your white colleagues are allowed to be mediocre. It's about knowing that any mistake you make will be remembered and generalized while your successes will be attributed to affirmative action or luck. It's about watching less qualified white colleagues advance while you're told you need more experience. It's about being asked to fix the very systems that oppress you while those systems resist change and protect themselves. It's about the constant code switching, the emotional labor of managing white fragility, and the isolation of often being the only black person in spaces where everyone else seems comfortable because the space was designed for them. Let me share stories from other black attorneys that illustrate different dimensions of this exhaustion. Attorney Michelle Foster, a black woman who practiced immigration law in Texas, talked about the specific burden of representing primarily black and brown immigrant clients while facing judges and opposing government attorneys who seemed to view both her and her clients as equally undeserving of being in America. Michelle described feeling like she was fighting for her client's humanity while her own was also being questioned, experiencing the particular exhaustion of trying to convince powerful white people that black and brown lives mattered when their actions suggested they didn't believe it. She eventually left immigration law after a judge made a racist comment about one of her Haitian clients and then, when Michelle objected, suggested she was being overly sensitive and playing the race card. Attorney James Patterson worked as a public defender in Philadelphia, representing primarily black defendants in a city where the criminal justice system was notorious for racial disparities in charging and sentencing. James talked about the exhaustion of watching his clients receive harsher treatment than white defendants with similar charges, of making brilliant legal arguments that judges would ignore, of seeing the system fail the people who needed it most. But he also talked about a different exhaustion, the burden that Black public defenders carry of being seen as saviors by their clients and communities, expected to single-handedly overcome systemic racism with their legal skills. James described the weight of that expectation, of clients' families looking at him with hope that he knew was often misplaced because the system was designed to convict their loved ones regardless of how good his defense was. He eventually burned out, leaving public defense for a teaching position at a law school where he hoped to train the next generation to be better than the system they'd inherit. Attorney Keisha Johnson worked in intellectual property law at a Silicon Valley firm, representing tech companies in patent disputes and trademark matters. Keisha talked about the exhaustion of being in a legal specialty where Black lawyers were even rarer than in other practice areas, where clients and colleagues seemed genuinely shocked that a Black woman could understand complex technical and legal concepts. She described being asked repeatedly if she had a technical background, with the implication that she couldn't possibly understand patent law without one, a question her white colleagues with liberal arts degrees were never asked. Keisha talked about the isolation of being the only Black attorney in her 50-person department, of having nobody who understood the microaggressions she experienced, of white colleagues dismissing her concerns about diversity as being too political or not relevant to the law. She eventually left the firm after being passed over for partner, while less experienced white attorneys were promoted, the final confirmation that her excellence would never be enough to overcome the biases limiting her advancement. These stories reveal patterns that data confirms. The American Bar Association's 2023 National Lawyer Population Survey found that Black lawyers report significantly lower job satisfaction than white lawyers, higher rates of considering leaving the profession entirely, and much higher rates of experiencing discrimination in the workplace. The National Black Lawyers Association's 2023 Mental Health Survey found that Black attorneys experience depression, anxiety, and burnout at rates nearly double those of white attorneys, and that the primary drivers aren't just long hours but experiences of discrimination, isolation, and the constant emotional labor of navigating predominantly white professional spaces. But here's what makes this especially tragic. Many Black lawyers enter the profession specifically because they want to make the legal system more just, to represent communities that have been systematically oppressed, to be the change they want to see. And then the profession grinds them down, exhausting them with the very racism they hope to fight, until many leave either the profession entirely or move to less impactful but less exhausting positions. The legal system loses talented advocates for justice precisely because it refuses to change in ways that would make those advocates feel valued and supported. It's a self-perpetuating cycle where the lack of Black lawyers is both caused by and contributes to a legal system that doesn't serve Black communities well. Yet despite all of this exhaustion, Black lawyers continue to make extraordinary contributions. They're fighting police brutality cases, defending voting rights, challenging discriminatory policies, representing clients that richer firms won't take, teaching the next generation, and slowly changing the legal profession from within even as that profession exhausts them. Their persistence despite the obstacles is remarkable, but it shouldn't be necessary. The legal profession should be fixed so that Black lawyers can simply practice law without carrying the additional burden of constantly proving their humanity and competence. What would that look like? Based on research and the experiences of Black attorneys like Jasmine, David, and the others I've mentioned, several changes are necessary. Law firms and legal employers need to move beyond diversity as a marketing strategy and actually change cultures that make Black attorneys feel unwelcome. This means addressing microaggressions seriously, creating mentorship programs that actually support Black attorneys rather than isolating them, evaluating performance based on actual work product rather than subjective, cultural fit that often means acts like white colleagues, and most importantly, promoting Black attorneys to partnership and leadership positions at rates proportional to their representation in the associate ranks. If firms can recruit Black attorneys but can't retain or promote them, that's a firm culture problem, not a pipeline problem. The legal profession needs to address implicit bias in how judges, juries, and other attorneys perceive and treat Black lawyers. This means training, but it also means accountability. When judges make racist comments or treat Black attorneys differently, there need to be consequences rather than dismissing it as isolated incidents. Bar associations need to take discrimination complaints seriously and investigate them thoroughly rather than protecting lawyers and judges who engage in bias. And law schools need to prepare Black students for the reality they'll face rather than pretending that legal education is a colorblind meritocracy, while also working to change that reality so future generations face less discrimination. Most importantly, we need to acknowledge that the exhaustion Black lawyers experience is a feature of the system, not a bug. The legal profession was built by and for white men, and it continues to operate in ways that advantage them while exhausting everyone else. Until that fundamental reality is addressed, until the profession reckons with its role in maintaining racial hierarchies rather than challenging them, Black lawyers will continue to be exhausted by practicing law while Black. If you're a Black person considering law school or practicing law, know that your exhaustion is valid and not your fault. You're not weak for struggling with burdens that your white colleagues don't carry. You're not imagining the discrimination you experience. And you're not alone. There's a whole community of Black lawyers who understand exactly what you're going through and who are fighting both for their clients and for a profession that values them. Seek out that community, because isolation makes the exhaustion worse. Join the National Black Lawyers Association, local Black bar associations, or informal networks of Black attorneys who can provide support and mentorship. And know that choosing to prioritize your mental health and well-being over prestige or partnership is not failure, it's wisdom. If you're not Black, but work in the legal profession, you have responsibilities too. Educate yourself about the experiences of Black colleagues rather than expecting them to educate you. Speak up when you witness discrimination or microaggressions rather than staying silent to avoid discomfort. Use whatever privilege and power you have to advocate for Black colleagues' advancement and to change firm cultures that exclude them. And examine your own biases honestly, recognizing that good intentions don't eliminate the unconscious assumptions that affect how you perceive and treat colleagues of different races. The legal profession could be better. It could be a place where Black lawyers are valued for their skills rather than tokenized for diversity initiatives. It could be a system that serves justice for all communities rather than protecting powerful institutions and perpetuating racial disparities. But getting there requires acknowledging the exhausting reality that Black lawyers currently face and committing to change that reality rather than expecting Black lawyers to just work harder to overcome racism that shouldn't exist in the first place. If this video resonated with you, if it helped you understand the hidden costs of being a Black lawyer, or if it validated your own experiences, hit that like button and subscribe for more content examining the realities behind professional success stories. Share this with law students, lawyers, or anyone who needs to understand that representation isn't just about numbers. It's about whether people of all races can thrive in professional spaces, not just survive them.